All rise. Circuit Court is in session. The Honorable Michael O. Saber presiding. You may be seated.
Good morning. We are on the record in file 24-21841-FC, People of the State of Michigan versus Dale Warner. We are at this point ready to proceed with the remaining preliminary instructions to the jury and then opening arguments. Is there anything that we need to address on the record before we begin our jury?
Yes, Your Honor. Just briefly, as far as the, there was a protective order that was over the x-ray of the tank, and that protective order anticipated that this would go to trial. We would just ask this court to allow us to disclose that x-ray at this point in time. I don't believe there was an objection.
No, Your Honor. The court had issued a protective order on February 26, 2025, and the order does appear to indicate that if this does go to trial, the x-ray would be used, but because the protective order is in place, Ms. Wise and I discussed the matter, and we think that the court just needs to issue a verbal ruling that the x-ray can be displayed in court and used at trial.
Okay then, so to the extent that that protective order needs to be modified to allow for that evidence to be displayed in court for the purposes of this trial, I will make that modification.
Thank you, Your Honor.
Thank you, Your Honor. The only other two matters are, one, there was a discussion in chambers about a text message exchange between Ms. Warner and a young woman named Madison. We had objected on hearsay grounds. The court had indicated that it does not believe it's hearsay, so that text message will be used during the government's opening PowerPoint. And then also we had a question about a photograph being used because there had been some enhanced photos. We discussed it with the government, and the photograph being used in the government's PowerPoint, as well as which will subsequently come in as an exhibit, is not an enhanced photograph. So I just wanted to make that clear on the record, so there will not be an issue. It's a still from a body cam.
All right.
Thank you.
That's correct, Your Honor.
Okay, and I would indicate that the discussion with respect to that text message is accurate. I did indicate that that text message, in my opinion, is not hearsay because it was not being offered for the truth of the matters asserted in that statement. I do recognize that it did involve two levels of hearsay, but I think that the answer is the same regardless. The text is not being used to establish the truth of the matters in those statements. Is there anything else we need to address on the record before we bring our jury in?
No, thank you, Your Honor.
No, thank you, Your Honor.
All right. seated. Good morning, ladies and gentlemen. At this point, I will be giving you the remaining preliminary instructions, and after that, the attorneys will make their opening statements. You will have a written copy of the instructions that I am going to read to you. You may refer to them during the trial. Since no one can predict the course of a trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a copy of my final instructions for your use during deliberations. Now I will explain to you some of the legal principles you will need to know and the procedure that we will follow in this trial. The defendant is charged with the crime of open murder. If you find the defendant guilty of murder, you must state in your verdict whether it is murder in the first degree or murder in the second degree. The defendant is charged with the crime of first degree premeditated murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Dee Ann Warner. That is, that Dee Ann Warner died as a result of blunt force trauma and or strangulation. Second, that the defendant intended to kill Dee Ann Warner. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Dee Ann Warner. That is, that Dee Ann Warner died as a result of blunt force trauma and or strangulation. Second, that the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Dee Ann Warner, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. You must think about all of the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. Premeditation and deliberation may be inferred from any actions of the defendant which show planning, or from any other circumstances surrounding the killing. The prosecutor need not prove a motive for the killing, but you may consider evidence of motive in deciding if there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. The defendant is charged in count 2 with tampering with evidence. The defendant is charged with intentionally removing, altering, concealing, destroying, or tampering with evidence to be offered at an official proceeding. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that there was some evidence to be offered in a present or future official proceeding. An official proceeding is a hearing held before a legislative, judicial, administrative, or other governmental agency, or a hearing before an official authorized to hear evidence under oath, including a referee, a prosecuting attorney, a hearing examiner, a commissioner, a notary, or another person taking testimony in a proceeding. Second, that the defendant removed, altered, concealed, destroyed, or otherwise tampered with that evidence. Third, that when the defendant removed, altered, concealed, destroyed, or otherwise tampered with that evidence, he did so on purpose and not by accident. Fourth, that the evidence that the defendant removed, altered, concealed, destroyed, or otherwise tampered with was used or intended to be used in a criminal case where open murder homicide was charged. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about April 25, 2021 within Lenawee County. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. She only has to show that the defendant actually committed the crime and that he meant to do so. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or the lack of evidence. It is not merely an imaginary or possible doubt, but a doubt that is based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where they give their theories about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes theirs, or may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents their evidence. Prosecutors may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has a right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of their evidence, the defendant's attorneys may also offer evidence, but they do not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all of the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening arguments, these are not evidence. They're only meant to help you understand the evidence and the way that each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide the case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all of the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of this case are is to decide which witnesses you believe and how important you think that their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on the witness's race, national origin or ethnicity, gender, gender identity or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was there anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade questions or argue with the lawyers? Does the witness's age or maturity level affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in this case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in this case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assumes or suggests that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to court staff, who will then give it to me. Do not show your question to any of the other jurors. If your question is not asked, it's because I determined that under the law, the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of this case. Sometimes the lawyers and I will have discussions outside of your hearing. Also, while you are in the jury room, I may have to take care of other matters which have nothing to do with this case. Please pay no attention to those interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all of the jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected with the case. This means that you may not speak to these individuals even if it has nothing to do with this case. You should be very cautious about speaking to people because you may inadvertently speak to someone who is connected to the case. This restriction is necessary to avoid even the appearance of any improper conduct on anyone's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and you are not allowed to discuss the case. If they continue, leave and report the incident to court staff as soon as you return to court. When the trial is over, these restrictions will no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. The restrictions I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside of the courtroom. Under the law, the evidence that you consider must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or social media platforms. You also must not research any aspect of the case during trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated these instructions, report it to court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all of the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Each night, your notes will be collected and locked in a filing cabinet. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see that we have chosen a jury of 16. After you have heard all of the evidence and my instructions, we will draw lots to decide which 4 of you will be dismissed to form the jury of 12. Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by the law. I may have more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken together, they are the law that you must follow. After my final instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. must reach your own conclusions about the case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. At this point, we are ready to proceed with the opening statements. Mr. McCree.